privacy risks cannot be overstated. I am pleased today to host this particular webinar today titled Navigating Legal Disputes in the Digital Age, AI and Digital Advocacy, the intersection of AI and cybersecurity. With me, I have a bunch of very, very professional and experienced panelists, and I would like to start to introduce them accordingly. The first panelist is Mr. Lawrence Ndinga, who is a lead consultant. Mr. Lawrence is a seasoned consultant with wealth of experience and expertise in cybersecurity, digital forensics, cybercrime investigations, and cyber capacity building. He holds a Master of Science degree in forensic computing and security from the University of Derby in England, an LLM in ICT law from the Open University of Tanzania, and a diploma in law from the Kenya School of Law, as well as Certified Information Systems Security Professional, CISSP. Lawrence has successfully led several projects related to data protection and privacy, such as the United Nations Office on Drugs and Crime Capacity Building and Digital Evidence Handling for frontline investigators, prosecutors, and judiciary in Southeast Asia member countries. He's also worked with UNODC in Rwanda for the National Workshop on Online Investigative Techniques and Handling of Electronic Evidence to counter the use of internet for terrorist purposes. As well as he has worked with the Council of Europe, specifically with Armenia, on capacity building for Armenian law enforcement and prosecutors on templates for data preservation and subscriber information, including drafting and effecting production orders in the obtaining of stored computer data in accordance with the Budapest Convention, Article 18. As well as that, Mr. Lawrence has worked with the East Africa Law Society on capacity building for lawyers, judges, magistrates, and prosecutors from Kenya and Uganda on a masterclass on digital forensics and electronic evidence handling and presentation for lawyers. The next panelist that I would like to introduce is Dr. Ademola Bambose. Dr. Ademola is a senior associate in the International Arbitration Construction and Engineering Group at Hogan Lovells in London. He's a key member of the Hogan Lovells Global Africa Practice and sits on the Global Steering Committee of the firm's Africa Future Leaders Group. Ademola is a solicitor advocate and has full rights of audience for civil matters at all levels of the English courts. He is also a barrister and solicitor of the Supreme Court of Nigeria, who represents clients in high-value commercial arbitrations and advises on issues spanning multiple sectors and jurisdictions. He has extensive experience advising clients in Africa-related disputes and risk management and emerging markets. Dr. Bambose is ranked and recognized by leading legal directories, such as a rising star in international arbitration. He has previously undertaken a commercial dispute resolution secondment in the legal department of a top FTSE 100 company in London. Prior to joining Hogan Lovells, he spent some time at the ICC International Court of Arbitration in Paris, also worked in the Lagos office of a leading commercial law firm in Nigeria, where he represented clients in complex and high-value disputes. Our other panelist is Mr. Nathan. Mr. Nathan is a partner at Hogan Lovells International LLP's International Arbitration Group, acting for large multinationals in complex and high-value international arbitrations and cross-border disputes. He has extensive experience in African-related disputes and coordinates the firm's disputes practice in the region. Nathan also has experience in other emerging markets, including Asia, India, Russia, and the CIS. Nathan has higher rights of audience in the English courts and regularly appears as an advocate in international arbitrations. He advises clients on risk management and strategies to avoid or resolve disputes at an early age. Nathan is a member of the advisory board of the Association of Young Arbitrators, Nigeria, AYA. After this brief introduction, I would like to welcome you all to this wonderful webinar session. And without further ado, would like to go to the first presentation session by Mr. Ademola and Ms. Sophie on Introduction to AI, so that we can better get an understanding of what AI entails and what are the benefits and risks of artificial intelligence in disputes resolutions. So welcome Ms. Sophie, who will be giving us a short introduction, and Mr. Ademola, who will be taking us through the benefits and risks of AI in disputes resolution. Welcome, Ms. Sophie.
Thank you very much, Edith, and good afternoon, everyone. Before we get into the substance of today's session, I'd like to open by giving a brief overview on what artificial intelligence is, where it stands today, and how these technologies are becoming practically relevant to legal practice. Firstly, to zoom out slightly, it's helpful to look at what the definition of artificial intelligence actually is. Artificial intelligence, or AI, refers to computer systems that are capable of performing tasks that typically require human intelligence. These systems can learn from experience, they can adapt to new information, and use data and algorithms to interpret complex situations, recognizing patterns and making decisions at speeds and scales beyond our own. And a simple way I like to think of today's AI landscape is to group tools into three broad categories. So we have predictive AI, generative AI, and the new emerging agentic or autonomous AI. So predictive AI learns from past data to sort, rank, and predict. In disclosure and e-discovery, we use these tools to group duplicate documents, rank likely relevant items, and spot gaps such as missing attachments or date ranges. In case analytics, they can extract dates, names, and issues from pleadings and witness statements to build timelines, highlight repeated themes, and flag unanswered facts before a hearing. And the value of predictive AI lies in its ability to sift through vast amounts of information quickly and consistently, giving lawyers more time to focus on analysis and strategy. Generative AI, it goes one step further than this, and instead of just predicting from data, it's trained to create new data. So in practice, this can mean drafting a first version of a client letter or summarizing long documents or cases so that you can get to grips with them quickly. And obvious examples would include tools like ChatGPT or firm-specific platforms, which we will get onto during the presentation. Because generative models can produce novel content, two issues are starting to become we're starting to see become really central in practice, and that's confidentiality and verification. Confidentiality is critical because using AI tools to process client data, it raises questions about data protection and transparency. Firms are still developing rules and guardrails around what can be shared with an AI system and how transparent you need to be to clients about the use of it. And verification is equally important. You may have seen recent cases in the UK and the US where lawyers have filed documents that have contained AI-generated citations to non-existent cases. Generative AI, it can hallucinate and invent sources and facts, and it's not always transparent about how it arrives at its answers. So when the point matters, it's becoming increasingly important to check sources and run independent research to fill the gaps. The next phase of AI development that we're seeing come in is agentic or autonomous AI. And these are AI agents that perceive their environment and take actions to achieve specific goals. These systems are able to combine environmental awareness, autonomous decision-making, and goal-oriented behavior. To make this more practical, if you think about legal practice, you can imagine an agent that's able to monitor a court docket, and when a new order appears, automatically files it to the matter, extracts directions, sets calendar holds, and drafts an action note for the team, all without you having to give it any prompts. We aren't fully there yet with autonomous AI, and it remains experimental, but there's significant scope for potential benefits, but room for error, and significant guardrails and human oversight will be needed as this technology develops. And in terms of why this matters, these AI capabilities are already helping legal teams move faster on routine work, freeing time for strategic analysis and client advice. And the key takeaway is that AI doesn't replace human judgment, but raises the floor of routine work so that you can focus on the parts that do require uniquely human qualities, such as critical thinking, empathy, advocacy, to name a few. So I hope that brief introduction helped to offer a bit of a framework for understanding AI's current state and its direction of travel and how it can support legal practice. And I'll now hand over to Adamola, who will explain the benefits and risks of AI in a dispute resolution context.
Thanks, Sophie, for that excellent introduction. I'm just going to build on what Sophie just outlined, and I'm going to be discussing the benefits and risk of AI in the context of Africa. Before I kick off, let me just provide a quick caveat and say that whatever criticisms I make during this presentation is not intended to dump down on the continent in any way. I'm a proud African, and even though I work in London at the moment, the bulk of my work, litigation and arbitration, is in Africa. So I'm still very much an African boy, and I'm aware of the advantages and fantastic things about the continent. But what I want to try and do within the limited time that I have is to see how AI can address some of the few challenges that we may be encountering in our practice. So the first benefit that we have on the screen is efficiency and speed. Now, one of the biggest challenges from my practice and from interacting with practitioners on the continent, one of the biggest challenges that we have in the court system is, the huge backlogs and delays in the litigation process. And again, I'm not ascribing the blame and I'm not apportioning the blame in any way. The point I'm just trying to make here is that AI can be used to address some of these challenges that we encounter in the process of litigation in Africa. So for example, we can use AI-powered tools to assist in case management. We can also use AI-powered tools to take notes. So our judges don't need to, write notes longhand. They can they can use AI tools. I was on a call yesterday, and we had an AI tool taking notes, preparing a summary of, first of all, verbatim notes of what was said, and preparing a summary. These are, tools that we can take advantage of to make our process very efficient. Also, AI tools can process vast amounts of data in a fraction of time that it would take a human being. And I think this is especially relevant in the context of international arbitrations, large international arbitrations, where you could have thousands, in fact, thousands, hundreds of thousands of documents. What AI can do, and what we use AI to do, is it helps in reviewing those documents very quickly. It can help in automating chronologies, bundles, cross-references in a fraction of the time that it would take a human being to do that. And so you avoid a situation where juniors, because they are bored or because they think nobody is looking, are not as thorough as they should be. AI should not be tired and should not be bored, at least in an ideal situation. And also in the context of domestic litigation, when you look at tasks like case review, analyzing precedent, identifying relevant documents, all this can be done very quickly with AI, and it creates room. And I think Sophie mentioned this already. It gives us as lawyers time to focus on strategy and decision making rather than administrative tasks. I mean, the administrative tasks are very important and they're integral to the process. But if we can find another way of getting some of these tasks done, then we should take advantage of it. And I mean, Sophie already made reference to what our tech brothers and sisters would call hallucination. And we're going to discuss this in more detail later. But the truth about it is that, yes, AI fast, efficient, but there are still teething issues, and I'll come to that. But the point I would want to make here is that, yes, there's hallucination. We need to still review, and I think Sophie mentioned that. But the benefit here is that rather than wait for a human being to spend hours and days to review a document or to prepare a document, AI can do that very quickly. But just the same way you would review a junior's work, to ensure that a junior has done things thoroughly, I think that's the same responsibility on us as practitioners to review AI's work product. The next point, number 2, is cost reduction. And I think this is one point that is especially relevant to the continent. In my day job, I represent both multinationals and local indigenous companies in Africa. And in my experience, I've found that, well, the multinationals usually have a bigger and larger war pulse to be able to fight their disputes. There's usually cost constraints with some of the indigenous companies, and this puts them at a disadvantage. Now, as a firm, as an individual who's passionate about the continent, we're more than happy to come up with fee arrangements to to accommodate cost constraints like that. But the truth about it is that some of the phases in a dispute that would usually take quite a bit of money can be efficiently done, and cost can be reduced by using AI. So, for example, document review, or what some our colleagues in the US may call discovery. We have tools. Sophie, for example, is in the process of reviewing documents heavily, and she's using AI-related tools, and the work is able to move very, very quickly. We'll discuss this later. I think Nathan is going to touch on this later. But for example, at Hogan Lovells, we have our own internal AI tools, and there are other AI tools there that can help review documents or can help make work easier. And the benefit for everyone is that clients benefit from lower legal fees, and just like we referred to previously, firms can concentrate on other aspects of the dispute, and they can allocate their resources more efficiently. The third point is better strategy. And when we talk about strategy, because we're no longer spending time, or at least as much time, on administrative and what I would call mundane tasks, we can spend our time devising a better strategy to allow us hopefully win our case for the client. Also on strategy, there are AI tools that can analyze historical data to predict, the likely outcome of a dispute. And so what this helps to do is that parties can make informed decisions as to whether or not they want to settle or proceed. You don't want a situation where at the very last minute, after seeing powerful submissions on the other side, from the other side, that's when you're deciding to settle. You can settle almost immediately, at least at the beginning, because AI could help to analyze. On a related note, and I think this is one of my favorite, my favorite points on this point here, on this particular issue, is that because AI can, look at historical data and analyze, what has gone on in the past and come up with, some form of guidance, what we're able to do as lawyers is that we can craft stronger arguments by identifying, weak points in the submission, and we can also identify factors that have influenced similar cases in the past. And so this way, you see what has worked in the past, you see what did not, and you can find a way around it. The next point and the final point, obviously there are other advantages, but the last point I would focus on is better document management and organization. In my experience, one major issue that many African jurisdictions face is with document management. And this includes the digitalization of records and the organization of case files. So I've worked on quite a bit of work of cases in the continent, and I've seen situations where the client's document management system is just in shambles. I was in a particular country in the continent a couple of months back, I won't mention, and I was discussing with members of the client staff, and we're looking for this smoking gun document from 20-30 years ago. And one of the staff members jokingly told me that you're looking for documents that the rats have eaten, and it's possibly in the belly of a rat somewhere. And unfortunately, many times, this is the situation with many of the clients in Africa and the emerging markets, and even generally. And the issue here is that many times we're fighting against an opponent with a better document management system. And so the client is left exposed because they lack the documents to be able to prove their case. Also, we're in a tight situation because you don't fully have all the documents. You are in a situation where you run the risk of making submissions that the other side can bring out documents to contradict. And so that just emphasizes the importance of document management system. Now, the point here is that AI can help to bridge this gap. AI-powered tools can organize and categorize large volumes of documents, making it easier for us to preserve documents and also making it easier for we as lawyers to be able to access relevant information quickly. Can we just jump to the next slide and discuss the risk of using AI in dispute resolution? And I'll start with point number 1, which is accuracy and accountability. Now, we've made reference to this already, to the issue of hallucination, where we said AI has been known to invent cases that simply do not exist. And this is problematic, obviously, for many reasons. Because now, while AI is very brilliant, the issue is that over-reliance on AI without applying a bit of common sense, it creates a very big risk for us as lawyers, obviously, because the courts would lambast us if it behave badly. And obviously, it's not a good look for us in front of our clients. But I think the issue here is we just assume that AI is fantastic, and it is fantastic, but just the same way like I always say, just the same way we would review the work of a junior is the same way we should review the stuff produced by AI. And so I guess the point here is, I think this is a question that people ask me very regularly, is that would AI take all our jobs as lawyers? No, I don't think so. We're not going to be jobless. I don't think AI is going to take our jobs. I just think that what would happen is that AI may be able to provide certain functions that human beings would be able to provide. And so maybe we may not need certain or as many people, but we would always need senior lawyers to review work. And obviously we would always need junior lawyers because we need junior lawyers to grow up to be senior lawyers. The point here being that we can't overly rely on the accuracy and accountability, of AI produced documents. We need to understand that AI, still has its own faults, and the way around that fault is to review work. The way around that fault is also to ensure that we continue to train our people so that they are able to identify some of these faults. Confidentiality and data security. I'm going to skip this and I'll come to this last because Lawrence is going to deal with issues relating to this. So I'll just go straight to bias, fairness, and explainability. Now, the issue with this is that basically AI amplifies bias and it skews review and outcomes. In the context of Africa, because many of the AI tools that we use, they are trained on data sets that may not necessarily reflect our diverse nature. Commentators would argue that, because it's not trained taking in consideration our peculiarities, it may not necessarily, or it may not always be suitable for us. And I don't think this is a point I'm making in relation to Africa, but not necessarily limited to Africa. It's just because AI, at least at the stage at which we are now, it's been created by human beings, and their biases sometimes feed into the creation of the tools. And just on that point is the fact that many AI tools or many AI systems, particularly those using machine learning, they operate as what we call black boxes, meaning that their decision-making process are not easily understood. And the lack of transparency can, undermine trust in AI driven dispute resolution, and it can make it difficult for you to challenge or appeal decisions because you don't understand how the decision that decision made by AI, which you've used, how it has been made. And so I guess the point here again is that yes, AI is brilliant, but if you're going to use AI, one thing to have in mind is that you need to diligently understand how AI has come to the conclusion that you are relying on. Again, you're not taking, information, results generated by AI, hook, line, sinker. You're, applying a bit of common sense. Legal recognition and enforcement. Because of time, I'll deal with this along with IP data rights and over-reliance, mainly because Nathan is going to touch on some of the disputes that would emanate from, that we expect, that we're seeing, and that would emanate from AI, and would, some of the future disputes that we would also see. But what I would say here is that, many African countries lack, at least as it stands, the legal framework to regulate AI. And so it creates a bit of uncertainty around accountability, liability, and also ethical standards. And the issue here is that in the absence of clear regulation, it could lead to misuse or the unethical application or use of AI in dispute resolution. So let's take, for example, if an AI system makes a harmful or incorrect recommendation, who is responsible? Is it the developer, the user, the organization deploying the AI? So there are some of these questions that still remain resolved. I mean, regulators around the world are probably still, for example, we have the SRA in the United Kingdom just approved the first AI law firm. And as much as that is fantastic news, and everyone is excited about that, the truth about it is that what the SRA has said is that ultimately, if AI gets something wrong, the promoters of the AI law firm will be held responsible. So that's something to have in mind. And just going back to confidentiality and data security, which is the final point. Like I said, Lawrence is going to spend quite a bit of time on cybersecurity. So I'll just move past this very quickly. But the point to note here is that in this day and age, there's quite a bit to be said about confidentiality and data security. And this is something that we must not afford to take for granted. On data security, Nathan and I, advising a leading tech company in relation to their operations across Africa. And one of the things that I have found is that many emerging markets, and again, not limited to Africa particularly, they lack robust data protection laws and enforcement mechanisms. And when they have this, when they have the laws, the issue that we sometimes would see is that we've not been able to, from the theoretical to the practical. And so these are some of the issues that we're seeing in practice. I'll yield the floor to Lawrence at this so he can discuss the issue of cybersecurity and data protection, especially in the context of virtual hearings. Lawrence.
Yes, thank you very much, Dr. Damola, for that insightful presentation, and Sophie as well. We've come to an understanding that AI is important, but there are so many other risks associated with AI, but it does not mean that it should be dismissed altogether. And as such, I would like to invite Mr. Gordon Myers, who is the head of the International Senior Lawyers Program Responsible Technology Initiative, to give a few remarks with regards to the session today. Welcome, Mr. Gordon.
Edith, thank you so kindly. And I'm so very glad to be here. Just a few brief remarks. I want to thank everyone who is here today, and thanks to the East Africa Law Society for working with us to convene this impressive gathering. I'm already fascinated by what's being said. So I'm Gordon Myers. I'm formerly the Chief Counsel and Head Technology Business Risk for IFC, and I'm presently head of ISLP's Responsible Technology Initiative. For those of you who may not know ISLP, we provide pro bono legal services in partnership with organizations like EELS that have direct knowledge and expertise in their respective jurisdictions and can benefit from international legal support to complement their own deep knowledge and experience. The Responsible Technology Initiative is worth mentioning just a bit. We're focused on both facilitating technology uptake to accomplish development goals and supporting practitioner adoption of responsible and ethical technology practices. I'm pleased to see that the last two slides actually address both of those issues. Our projects include technology transfer, representation of Indigenous communities, legal reform and capacity building, including artificial intelligence risks, access to justice, and freedom of expression. We prioritize working with trusted partners in the region, like EELS, who share our values and objectives and can bring context, insight, and practical relevance to our work. I'm looking forward as much as you to this exceptional panel speaking to critical issues of cybersecurity, artificial intelligence, and dispute resolution. And so with thanks again to our speakers from Hogan Lovells and EELS, as well as the remarkable team responsible for the mechanics and logistics of this program, I'd like to turn this again back to Edith, who's been eloquent and helpful. Thank you again. I will certainly stay on for the full session, and I hope that you will too. Thanks again, Edith.
Thank you very much, Mr. Gordon, for that brief remark. And without further ado, I would like to welcome Mr. Lawrence, who will be taking us through cybersecurity and data protection in virtual hearings. Mr. Lawrence, welcome.
Thank you very much, and good afternoon to everybody. Okay, I think since the COVID lockdown, many courts have moved to virtual, which means that it is very important aspect nowadays in running the proceedings of the courts. So, in order for us to understand what is important in the virtual hearings, there are certain things that we need to have a background on. That is, what are some of the cybersecurity principles that we need to understand? And what are some of the data protection principles that we need to understand so that we can be able to apply those principles in virtual hearing? Now, there are three aspects of cybersecurity that we really need to understand. That is, one is the confidentiality. What is confidentiality? And this is what we normally call the CIA triad in cybersecurity. So what is confidentiality, which is a very important aspect when it comes to virtual hearing? Now, confidentiality means keeping the secret, which means that the information should only be accessible to people who need that information. So in terms of data that is being used in virtual hearing, that data should be confidential and it should only be available to the people who are supposed to be using it. Now, there are two aspects of confidentiality. Now, when we are talking about confidentiality and of personally identifiable information, then we call it privacy, which means that we are maintaining confidentiality, but in relation to the personal data. Now, there's also the aspect of secrecy. Now, when we say confidential, something's confidential, which means that the bad guy might know that the information is available, but they cannot access that information because they're not been given the rights. But there also the other aspect of confidentiality, that is the secrecy. That is the unauthorized is unaware of the communication or information assets. Now, The other aspect of the other aspect of cybersecurity, that is the CIA, is the I, the I, that is the integrity of the data, which means that the data that we are going to rely on in virtual hearing, we need to actually ensure its integrity. So what is in integrity? Integrity means the accuracy. It means just go back to the last slide, please. Yeah, it means the accuracy of information. That's the accuracy of data. Is this data accurate? The data that you are relying on in virtual hearing, is this data accurate? Now, the other aspect of the other meaning of integrity means authenticity. Where is this data coming from? Because for you to trust that data, you need to trust the source of that data. So authenticity is an aspect of integrity. Then there is also the aspect of consistency. Is this information consistent? For instance, when we are talking in relation to virtual hearing, and our witness is giving testimony, is that are they consistent in their testimony? So that makes integrity very important in virtual hearing. Next slide, please. Now, we also there are also two aspects of integrity. There's the integrity protection, that is simply putting in place measures, technical measures that keep the bad guys away from information. And there is also what we call integrity verification. Now, that is to verify the accuracy of data at the time of use. What do I mean by this? When you are using data to make decision, by the time you are creating that data, at the time of creation, we ensure that that data has got integrity. So that is where we normally use the digital signatures to make sure that the data that we are creating has got integrity. So that by the time or at the time of use, we verify that data to ensure that that data has not been changed in any way. And this is very important technically in virtual hearings, because we need to ensure that the evidence that is brought in court, that evidence has not been altered in any way. And there are ways that we can check that by using technologies like the digital signature to ensure that the integrity of data is maintained. Then there's availability. Now, during the hearing, the technology must be inclusive and provide equal access to all participants. So availability is very important in the virtual hearing. So these three aspects of cybersecurity, the CIA, that's confidentiality, integrity, and availability, are very, very important as in virtual court hearings. Next slide, please. Now, we've talked about the cybersecurity principle. So what about the data? I'm sorry about the title here. This should be data protection principles, not cybersecurity principle. So when we are talking about data protection principle, we are talking about things like lawfulness, fairness, transparency. That is, all the participants must be able to know that their data will be processed, how it will be processed. So this is important for all the participants in the virtual hearing. Now, there's also the issue of purpose limitation. If you're collecting data, participants must only data must only be used for the purpose of the hearing, not any other purpose. So the other thing is the data minimization. Only data strictly necessary for the hearing must be processed, not processing every data. And then there is also storage limitation. What is the retention period for the recording, which have been recorded during the virtual hearing? Next slide, please. We're also talking about integrity and confidentiality. That is, the court should put in place a strong technical and organizational measures during the virtual hearing. And the last is accountability. That is, the courts must be able to demonstrate the compliance to the required laws. For example, if it is each and every country has got their own privacy laws, so the court must be able to comply with that. We know that the model law for the data protection is the GDPR, but many countries have now developed their own national laws based on this model. Next slide, please. Why does it matter to virtual courts? First of all, confidentiality. We know that we need to, the hearing must involve sensitive or personal or commercial data. So there must be confidentiality. You must put in place measures that maintain that confidentiality. We've also talked about integrity, that is, evidence must not be altered or tampered with. Then there is also the issue of fairness, fair trial rights. Each and every participant has got some rights. So the participants must trust the process and have equal access. Then we talk about the compliance. That is, the courts must align with national data protection laws and human rights obligation. Next, please. So what are some of the sensitive data in virtual courts? One, we have personal data. We have names, we have the addresses, we have ID numbers, contact details of parties, witnesses, and legal representatives. So this is data that is sensitive, that must be kept confidential and must be maintain the integrity. Then there is the judicial data. That is, we are talking about case files. We are talking about judgments. We are talking about court records and deliberation notes. These all are some of the sensitive data that needs to be kept confidential and integrity maintained. Then we have the evidence itself. Evidence can be in form of audio. Evidence can be in form of video or forensic reports and digital exhibits. Also, we must ensure that the integrity of that evidence is maintained. Confidential information, that is attorney client privilege, communication, and in-camera proceedings. Those are some of the confidential or sensitive data that needs to be kept confidential and integrity maintained. Next. So what are some of the cybersecurity risks in virtual hearings? First of all, there is unauthorized access. That is, hackers can actually intrude and get data without authorization. That is, or an insider who is not authorized can be able to access data that is confidential. So that is one risk. That is, we also know that during when you are having a Zoom meeting, there's always these Zoom bombings. That is somebody intruding into the conversation and bringing some things that are not considered, which are unethical. Then there is the weak authentication. Most of the connections, we find that they have weak authentication. That is, they rely on simple passwords. So there is no what we call the multi-factor authentication or two-factor authentication. Then there is data interception. somebody can, through an insecure Wi-Fi or an encrypted connection, can actually intercept the data which is being transmitted during the virtual hearing. Then there is also the data breaches, that is exposure of code files through insecure platform or cloud storage, and tampering of the data, that is alteration or deletion of the evidence. Then we also talk about privacy violation, that is inadequate anonymization or of vulnerable witnesses. Next. So we also talk about cross-border data transfer risks, that is jurisdictional conflicts when data is stored in foreign servers, because most of the data protection laws require that personal data should be actually stored within the country. And so we have this issue of cross-border transfer if the data is kept in a foreign country. Then there is the data storage vulnerabilities, that is recording stored in secure location. That's also a risk. Then we are talking about phishing and malware. We know that nowadays the hackers or bad guys use a lot of phishing technologies to target people and steal information. So people like officials or court officials can be targeted by phishing and malware. Then human error, that is the accidental disclosure or poor handling of digital evidence. Next. Now, what are some of the safeguards that the courts can take into consideration? I've divided this into three, that is the technical measures, procedural, and institutional measures. Now, in technical, what needs to be done is when there is a court session, the proceeding is continuing. There must be an end-to-end encryption. That is for video hearings and evidence transmission. That must be in technical measures must be put in place to ensure that. Then there is the multi-factor authentication for all the participants. You should not rely only on simple passwords when you are logging into the court session. Then there is the role-based access control to restrict case-sensitive files. Role-based means that you do not create explicit rights to individual. Rather, you create rights to roles that are assigned, and then you assign a participant, or you assign a person to that particular role. Then we can also use blockchain or digital signatures to ensure evidence integrity. This is a very huge topic when we talk about digital signature to ensure the evidence integrity. And I think we cannot get into that now. Then procedural measures, there must be clear data classification policies. How is the data classified? And this depends on the courts itself. You can classify some data as restricted, you can classify some data as confidential, or you can classify some data as public. Then we talk about secure channels for filing and sharing documents. How do you file documents? And most courts nowadays have gone to online filing. So how do you file? Is the channel for filing, is it actually secure? So that must be put in place. Next, please. Continue with procedural measures. We are talking about rules for recording and storing virtual hearing. This again borders on policies within which are created in the court organization. Anonymization and vulnerable participants. this is also something that you do not put the full, let's say, sensitive data can be anonymized so that somebody cannot be able to put 1 + 1 and know this, get the information that that is restricted. Then there's also the regular cybersecurity and audits and penetration testing for the systems of the court to ensure that they are actually aligned with the policies of the CIA. Then we have legal and institutional measures, that is the data protection regulation aligned with the GDPR or national privacy laws. We know that GDPR is actually the model law that many countries have used to create their own national data protection laws. Then we have judicial training on digital security awareness. I think this is a big problem because in many cases, I've been training judges, I've been training magistrates and lawyers, and we find that when it comes to digital security, they are very much unaware of how the digital data or cybersecurity, what cybersecurity is. So this training must be done for the participants, or for the judiciary, to ensure that they at least there have some awareness on cybersecurity. Then we have incident response framework for data protection breaches. Do you have in place incident response framework so that if something happens, how do you go about it? So that is what we call incident response, which means that if something happens, then how do you ensure that you can be able to recover from that incident? Then we have clear accountability between the courts, the technology providers, and the participants. So if we can put those cybersecurity safeguards in place, then I think we'll be able to secure sensitive data which are used in the virtual court hearing. I think that is the last slide. Okay, yeah. What are some of the checklists for conducting virtual proceedings? That is authorization. Only desired participants must be able to attend. Not everybody. Authenticity, we talked about the sensitivity, ensuring the identity of the participant. Then privacy, keeping the conference private through encryption. And we can also use private or public infrastructure. When you are using public infrastructure like cloud hosting, you must ensure that proper security is put in place. Then the last one is the user management. That is, how do you authenticate the participants in the court hearing or virtual court hearing? Thank you.
Thank you very much, Mr. Lawrence, for that insightful presentation on data protection and virtual hearings and cybersecurity's principles when it comes to virtual hearings. So without further ado, I would like to welcome the next speakers, Mr. Nathan and Dr. Ademola, who will be taking us through the third session, AI, source, subject matter, and application. Welcome, Mr. Nathan and Dr. Ademola.
Thank you very much, Edith. So I'm going to talk a little bit now about artificial intelligence as both the source and subject matter of disputes. So yeah, Lawrence has talked a lot about when we're using it in a hearing, but often we encounter in the course of a hearing, or indeed our day-to-day legal practice, potential risk areas for clients that they need to manage. So the first area that we see is contract breaches arising from faulty system failures. And here in the UK, we have the recent example over the last few years, which has given rise to court proceedings, inquiries, and even a TV miniseries of the failure of the post office technical system. So the post office had a system called Horizon that was to do with their accounting software. And yeah, they had the situation where a lot of their sub postmasters were saying that the accounts, didn't reconcile and that there was a problem with the system. Yeah, in what's been described as one of the biggest miscarriages of justice that the UK has ever experienced, the post office said, well, the system must be right, and proceeded to prosecute these sub postmasters. Some spent time in prison. Yeah, others were repaid amounts that were said by the system to be stolen, but were in fact not stolen at all. So again, that's a really extreme example of the type of legal issues that clients face. Clients want to be early adopters of AI, adopt these systems, but actually, are there risks? Can they be wound back? And what's the testing environment? What are the procedures in place for escalating and dealing with problems that arise under the contract with suppliers, or for problems to be flagged internally? Yeah, it's important as lawyers that we're able to help clients navigate these new systems. It's fantastic you're doing it, but actually, have you thought about these things? Another is that the liability claims for harms caused by AI systems. What AI systems can do is that they can, yeah, increase efficiency, but also if something goes wrong, they can quite quickly multiply the errors. And we're seeing things now like with these bots who are trained to provide certain answers. Well, who's responsible when the AI system gets it wrong? Is it the coder? Is it the software company? Is it the company who they're representing? And how are you going to deal with those issues? Driverless cars, they have a crash. Who's responsible? And then you also have the potential for IP disputes, particularly where we're seeing that where AI needs to learn, as Sophie mentioned, to improve. Well, what's the copyright? What's the underlying intellectual property in those things that it's learning from and then, in a sense, reproducing? And I mean, this is an interesting one where we're seeing it in the context of media and newspapers. A lot of newspapers, they're online, but they make their revenue through advertising and clicks onto their main page. But what they're seeing now is that search engines are summarizing the content of the articles on their webpage, so that actually the person just looks at their search engine, it comes up at the top and gives an AI summary. And so they're not clicking through to the media companies or the newspapers webpage. And so, suddenly their clicks are down, and that's removed their source of revenue. But what they now need to be thinking is, well, how are we licensing that content, to the to the search engines? Because they're putting their AI on the top, but actually their AI is is getting the benefit of all the hard work from our article, which it's just read. So again, you're going to see licensing issues there around the large language learning models, because AI is a bit like a sausage machine. You put garbage in, you'll get garbage out. So they want these high quality inputs in, but how is that going to be licensed, and what are the IP disputes that are going to come out of that? And so and of course, we've seen a number of big cyber attacks as well. disrupting businesses. So AI is fantastic when it works, but actually it means that people can get into the system, and there's a big automotive company at the moment that's subject to a cyber attack, which has had to stop production. So again, as lawyers, we need to be helping clients to put in place contingency plans, and thinking about how to deal with those situations. And then also thinking about these cases where AI does produce the wrong answer. And it's something that in-house counsel are thinking about. I was listening to an in-house counsel at a tech company. He was asked, well, how do you use your product? He says, you don't want to know how I use it, because my job is to try and break it. There are he is trying to think about ways in which people could put things that are inappropriate into the product, and where it would breach the rules, because again, you have to remember that AI just follows the rules, and it doesn't have unless you put in every rule and think about every context. When it gets to a new one, it will just follow the existing rules. And I know that there's a test recently that they ran on lab testing of an AI, where it had access to the emails of an executive, and in those emails there was evidence of a hypothetical affair, but in the same emails the executive was going to turn off the AI system at 3 o'clock that afternoon. And so the AI learned and tried to blackmail the executive by saying, don't turn me off, because otherwise I will release these emails. So again, it's about making sure. Now, I appreciate that's in the lab, a test environment, a bit of an extreme example, but it's helping clients think through these things, because they're always looking for how to identify these risks, and whilst at the same time allowing technology to be adopted rapidly, because they're often on the cutting edge, and there are benefits. So it's important that we as lawyers help them navigate these issues, and are seen as gatekeepers, whereby we can identify the risk, but we're letting people pass through, and not just blockers. So I think the lawyers who are really effective at spotting these issues and working with clients, are really going to be successful in this in this field. And it's important that all of us as trusted advisors of clients learn about it, so that we can help them on this journey. So I now hand over to Dr. Bambotti.
Nathan, I was still laughing in the background about the blackmail story, but let's just let's just to the next. Sorry, next slide, please. Yes. So here we're going to discuss AI's application in the dispute resolution process, and I'm not going to spend a lot of time here. First, because we're out of time. Secondly, because we've already referred to many of these points in the course of the presentation. So the first one here is legal research. We've said that AI could be used for faster, more targeted searches in statutes, case law, and commentary. I guess the point to add to that is that the right AI tools can also propose authorities, and it can help to synthesize threads across cases and commentary. Again, the caveat here is AI hallucinates, and so as much as you're relying on research notes generated by AI, which, to be honest, can be very helpful, it's important that you check the primary sources to prevent a situation where you're relying on fabricated cases and misapplied references. The next point here is document review. Again, something we've referred to extensively, and it's the point that AI-powered document analysis, it can help to review documents, especially when you have large number of documents, and we use AI regularly to review documents, to code documents, to identify privileged documents, to identify privileged documents, to identify confidential documents. All we just need to do is feed in some information into AI, which is very helpful, because rather than review thousands and thousands and hundreds of thousands of documents one by one, AI can help to streamline the process. Again, it's important that human beings are involved in the process for spot checking, for quality control, because ultimately we are the ones responsible to the courts. We're the ones with ethical obligations and legal obligations to the courts. So it's important that human beings are there to just ensure that things are going right, and that's what we typically would always do when we're using AI to review large volumes of documents. The third point here is drafting support, and again, yes, AI could be used to produce drafts of pleadings or advice notes, and from some of the cases in public domain, the cases relating to hallucination, I think it's pretty clear. Again, the caveat here is that as much as you may want to use AI to draft documents, or for whatever reason, there's confidentiality, especially in the context of arbitration, the extent to which you can put in confidential documents on publicly available, on tools where the confidentiality of whatever you put in there is not guaranteed. That's one. Number two is that there still remains the place for lawyers to refine facts, to apply strategy, and to control the tone. Because again, when you talk about tone, the tone would reflect whoever created the AI tool. And especially for those of us who do international arbitration, you would realize that there are certain tones that would work in certain jurisdictions that may not work in some other jurisdiction. As a Nigerian lawyer, one of the things that I found when I qualified in the UK is that certain tones that I may use and get away with in Nigeria, I may not be able to get away with it in the UK, and vice versa. When I have my Africa-related cases, Nigeria, wherever, Kenya, Ghana, Uganda, Tanzania, I realize that sometimes I need to think like the tribunal that I have to be able to put forward the case. And so if an AI tool has been created based on, for example, a UK style, and I'm appearing before a Tanzanian arbitrator, and you need to refine stuff. So those are some of the things that you just need to have in mind from a practical perspective. Legal analytics, predicting case outcomes based on historical data. Again, something that we've referred to. AI could help in synthesizing historical disputes to predict chances of success. And again, we discussed when we're discussing benefits and risk, that's helpful because it can help to facilitate settlement, helps you to facilitate to be able to make better, stronger submissions. Again, but like drafting support, each case is unique, so the accuracy of AI generated results needs to be carefully examined. Many times it's right, but you can't afford to take it hook, line, and sinker and think that it's the gospel truth. So that's one thing to be careful about. Case management, automation of scheduling, filings, and deadline tracking. We've discussed this extensively, and we've said automation can schedule deadlines. It can help in tracking filings, and it can keep teams aligned across sorry, I was just looking at the screen. And it can keep teams aligned across jurisdictions, reducing process risk. And this is very important in international arbitrations or international disputes where you have teams working across multiple jurisdictions where you need to be able to bring everyone together. And it's something that we use regularly when we're working with our colleagues in the continent, because we want to feel like a joined up team. And so AI is one way by which we can, create a platform where everybody can feed in their documents, feed in their information, and we feel like even though we're in different offices at different jurisdictions, we're still one team. And the final point here is evidence analysis, pattern recognition in large data set to support arguments. And again, something we've referred to in our introductory remarks, which is AI could be very useful in identifying, patterns. And this is especially helpful because it can help to, reveal anomalies. You can use it to support expert opinions. And it helps us to be able to draft submissions around some of the limitations that one may identify. The issue behind evidence analysis still remains what some of the things that I said, how do you explain AI generated information? So again, there's still the need for lawyers to do some work. Now, the advantage is that what would ordinarily have taken a junior or a lawyer, anybody, quite a bit of time, so 3 days, for example, or 4 days, or 10 hours, AI can do it very quickly. But the important point that, I need to just flag is that, yes, AI can do some of these things very quickly, but AI is not a human being. AI has been created based on personal biases and information. Yes, AI is going to evolve over time, but we just need to be careful that the courts, the regulators, whoever is assessing whatever information that we're putting forward would hold us personally responsible as lawyers. Next slide, please. AI's application in dispute resolution. I think this is just expatiating on some of the points that we've already discussed. And so document review. Under document review, you can use AI to translate foreign documents, documents in foreign languages. So rather than initially engaging a translator, paying lots and lots of money to engage a translator. And sometimes, yes, you still ultimately need a translator, especially if or when the tribunal or the court wants something certified. What you could do is you could use, simple AI tools to translate foreign language documents into, whatever language you want it to be. But like I said, there's the question as to whether, for the purposes of formal submissions, whether or not you need something more formal. Automatic duplication of email chains. Yes, I think that's self-explanatory. Search term-based disclosure. And this is something that we use from time to time. Once documents from have been uploaded, you don't need to look at documents one by one, just like you would search your email and you can put in a word to help you identify whatever it is that you need. Due diligence based on search terms, that's self-explanatory. Relationship mapping, pattern recognition based on common terms, and communication exchanges. Again, coding, you are trying to flush out or trying to fish out certain specific information. You can use AI tools to be able to review large volumes of documents without one person having to look at each page one by one. Again, the caveat is quality control. The caveat is, spot checking. The caveat is just ensuring that the tool is working properly. Factual analysis is something, and again, we referred to it in the previous slide. AI can be used to prepare summaries of specific documents. So you have a large piece of document you want to give a junior, rather than give someone who would spend days or hours and hours. Yes, you can get AI to prepare a quick summary of a document that is being reviewed or that needs to be reviewed. Again, there needs to be quality control so that you don't fall into the error of AI adding facts that don't exist. And same thing with summary of case files, relationship mapping, pattern recognition of case files, and suggested cross-examination questions. That's an interesting one because, again, AI is bright and intelligent. You can put it in and get AI to suggest questions. And yeah, sometimes it would come up with intelligent questions that you may or may not have fully thought to be relevant. But let's not forget that you as lawyers, or we as lawyers, we have ultimate control and knowledge about the case. There are certain human elements and certain, personal things that may have come up that may influence how we approach a case or how we put certain questions across. And so as much as AI can be used for some of these things, it's just important that we remember that there's still the need for human beings to look at these things, refine these things, and again, properly understand. Because again, I've seen videos of people reading out speeches that they generated from ChatGPT, and apparently ChatGPT would say, please let me know if you want me to refine this, and the individual who is reading the speech says, please let me know if you want me to refine this, and you know that it's been generated from ChatGPT, and you know that the individual has not engaged his or her mind properly. We don't want to fall into that situation in court or in front of your client. So please let's be mindful of that. And finally, legal analysis, summaries of legal principles based on specific textbooks and authorities. That's similar to summary of specific documents and case files that we discussed. You can, get AI to prepare a quick summary. The caveat still remains that you just want to ensure that, just like the way you would review a junior's work, to ensure that it's been properly done, you just need to ensure that AI has not done shortcuts or invented things. Summary of legal principles derived from internet-based materials, self-explanatory, predictive analysis, pattern recognition based on case type or jurisdiction. And this is something that we discussed earlier on. And again, the point to reiterate here is that predictive analysis sometimes reflects personal biases or, whatever has been done in the back end. And, I think what is very important for us as Africans is that we remember that when applying some of this information that we've used AI to generate in Africa-related cases or, specific instances, that we continue to remember that we need to ensure that it's relevant to our circumstances. Generation of legal submissions, we've discussed that, but you don't want to fall into the high-profile cases where they are blasting, the judge is criticizing you for obviously relying on AI to ChatGPT to make your submission. So you're still responsible for that. And finally, prediction of case outcomes based on pattern recognition and specific case sets, case facts. This is something we've referred to. AI could be very, very useful in doing this. But again, you need to tailor it, you need to review it, and you need to ensure that the conclusions are specifically relevant for your circumstance. Next slide. I think this is probably Nathan. Yes, this is Nathan. Nathan, over to you.
Thanks, Ademola. So looking at some recent developments, as Ademola's already mentioned, the SRA approved the first AI-driven law firm. I think it's important to note that the law firm is quite limited in what it offers. It is using AI to help people fill out forms for small debt claims. So again, very focused area. And what will happen is that AI will help fill out the forms based on the input that people put in, and then a lawyer will review it. So you can sort of see that for some claims that may be appropriate, but that's not going to be something, as Admiral said earlier, we're not about to see all our law firms replaced by AI, but it does give an idea of where you have those uses, and it's maintained and reviewed properly. It can lead to efficiencies. But at the end of the day, it's important to remember that with artificial intelligence, AI, we also need to apply our actual intelligence. And what we have seen in a number of jurisdictions, the US, Australia, the UK, Kenya, and South Africa, I think, but we'll see it in many more, is where parties have used AI to prepare their submissions. And then AI has cited authorities that don't exist. And that creates a professional conduct issue. It also creates issues. How does the court deal with that? Does it just disregard the submission, or does it require the same lawyer or a new lawyer to do it again? We're seeing courts look at imposing sanctions on the individual lawyers. So it's important that even if AI is used, that at the end of the day, we have professional duties, and the buck stops with us. And so it's important to manage the benefits and the risks. For our own processes where we're using AI, as well as helping clients to put in place these appropriate governance processes. And one thing that you'll also see is that because of some of the confidentiality and IP issues that have been flagged with with using the readily available tools that are free on the internet, that you're starting to see some firms creating their own AI platforms. So at Hogan Lovells, we've got AI systems called Craig. And what we're seeing is that we have internal governance procedures around how that's used. We obviously need to get client consent before putting documents up there, but it allows us to have a closed universe of what Craig is learning from. And as Ademola mentioned earlier, there's lots of different uses that come with different risk levels. And so what we have is for each new use category, and this is being updated all the time. If you're going to use AI for something new, you need to think about what the risks are and get sign off from general counsel's team and ensure the client's on board. So I think there are these, but it's important for you if you are co-counseling with an international law firm, whether it be on transactions and due diligence or in the context of a big arbitration or litigation, that you make the most of these tools and you ask them about their AI capability and their tools, and how that might be able to be used for the benefit of you and your clients. So again, just to flag that that's another development that we're seeing more broadly in the legal landscape. You've got the one these AI tools that are developed just for a particular firm, but we're also seeing AI tools that are just that are developed for the legal community more broadly. Yeah, again, that are just focused particularly on the, you know, on the risks, the risks and and the benefits. And what we are starting also to see is some of, and I'll mention this, some of this data analysis of previous cases. So not just looking at what the principles are, but how many of these type of cases have been decided by this judge, where this argument has been run, to pro or for and against. And so I think some of those percentages are a useful starting point to see, well, look, this argument's been run a lot of times, hasn't been that successful, or but again, without knowing the why, I think there's a real danger in relying on those percentages, because as we know, in cases are decided on an individual basis by a judge applying the specific facts of the case. So obviously where cases are identical, the doctrine of precedent would, you would expect the same result, but it's relying on AI to pick up those similarities or differences. I think can be can be potentially problematic, particularly if it's then going directly into some sort of merits advice. And I also have had lawyers who said, well, look, our client has put in their legal question and then come to us and said, well, look, this is what this is what AI on the internet has said. And I was talking to a lawyer who was very frustrated because the AI on the internet was had come about wrong analysis. But the client had come expecting that is what the answer would be, and they had to explain, well, look, no, actually, this is AI has prepared some summaries and pulled things that just don't represent the law. So again, something we need to be conscious of with clients. And then of course, along with AI is also thinking about how we're charging clients for that use of AI, because again, it's cutting down on the number of billable hours, but lawyers who are upskilling themselves, identifying the tools, dealing with those risks, need to be thinking about, well, how do that is bringing value to the client. How does that turn how does the value that I'm bringing then, how is that paid for by the client? And so again, those type of issues, because these tools to get right require a lot of investment, and how to balance that in terms of pricing. So those are some of the things that we see on the horizon, and current trends in terms of the use of AI within the legal community. So I think we're now moving on to the next topic, which is the role of lawyers in navigating AI. So if we can have the next slide, please. And this is really drawing it all together. Our role as lawyers, we're trusted advisors, and we have to help our clients navigate this this complexity. It's no good saying there are so many risks, don't do anything, because the reality is that businesses have to adapt AI because it is it's so critical to their business processes. It's so critical to innovation and to keeping up with the competition. So all we need to do is we need to be able to help them put in place governance arrangements, identify the risks, set how they're managed. Even if it's, well, every time you're adopting new software, or you're putting it into you're using it for something different, there should be a process to go through. I think there are those businesses that we're not using AI, but every employee comes to work with a smartphone. Yeah, and literally, yeah, AI is a click of the button away. And so people are using AI to assist them with the work, but not doing it through the system. So it's important to actually say to clients, look, you have to embrace the reality of what's happening here uh, and and help to manage the risks and understand what it's being used for, what you can and what you can't use it for, so that the business can manage those risks and not end up being one of these case examples that we talk about, where something's gone wrong. Yeah, engaging with regulators. Yeah, the technology is changing all the time. People say, tell me what your favorite platform is. But the answer is that there are new platforms coming all the time. Existing platforms are changing what they're doing. It's dynamic. You need to think about what you need to use it for and then what's available. Um, and, and regulators are struggling to keep up. And so you've got regulation that might be several generations behind in terms of the technology, regulating something that wasn't contemplated. And particularly as we get AI doing more and more, the issue of responsibility for the AI. So it's important to be able to assist clients to interact proactively with regulators. Don't wait for the regulators to try and impose some sort of regulation on you. Regulators are wanting to be seen to act quickly in this area. And I think that's important, but they often need help thinking through what the implications of those regulations will be, because they don't have the same understanding of, well, these are the issues with it from a business perspective. You need to think about the other contracts, how are issues like IP ownership, licensing, um, and performance issues, because often actually having the right to sue the provider is not that helpful. What you really want is for the provider to have to send people onto site to fix the problem. And if they can't fix it, if there is code or what have you that's confidential to them, but if this system's business is critical to your business, well, you would want a right to be able to step in, to have code held in escrow so that if they can't fix it, then you can get another firm in to do so, and that in that circumstance you have rights to access the code. So there are all these type of things to be thinking about when businesses are engaging in the process of supply of business critical infrastructure. So again, it requires someone who's got a bit of an understanding of what actually what would we want in the event that this goes wrong. Thinking about incident response, what happens when a cyber attack occurs, who needs to know. It's both they're often reporting obligations, so legal reporting obligations to regulators. There is managing the legal and stakeholder risk, but also in terms of the technical side, who gets told so that technical solutions can be worked out, because the last thing you want to be doing is trying to deal with all these issues when a cyber attack has arisen, because time can be quite critical. And what are the triggers for taking a system offline? When is it so bad that you need to pull the plug? Again, discussing those issues in the when you're putting a governance and policy document together can be done in a much more considered way than when there's a problem and you're having to decide what to do. And then again, as lawyers, we need to be learning and making sure that we are on top of enough of these issues that we can ask clients the right questions. So some of it's training ourselves, but also training clients around the intersection of legal obligations, and technical developments. Why do we want to know about new uses? What are the issues? Because we need to put rules and boundaries around the technology. And lawyers who do this well will be extremely successful. These will be the trusted advisors to the leading tech companies that we probably haven't heard of, that will be big names in 5 years' time. And so I think there's a real opportunity for us as lawyers to embrace this and help our clients navigate these challenging and if you get it right, very rewarding waters. So I think, subject to Edith's view, I think it's now time for questions.
Yes, Nathan, thank you very much for that very insightful presentation. And thank you, Ademola, also for the presentation. For the participants, please, you may pose your questions in the questions and answers section as we wrap up the session. So thank you to all the speakers, Mr. Lawrence, Sophie as well, for your insightful presentations as well. What we have been able to gather from this particular presentation, firstly, as the definition of AI. We need to understand what AI entails. We need to understand the definition of key terms in terms of, our legal practice, in terms of virtual hearings. What sort of AIs are we talking about? What sort of tools are we talking about that are subject to this discussion? But also we've seen the benefits of artificial intelligence in virtual hearings, in domestic, international hearings. We've seen the benefits such as, cost reduction, better strategy, better documents management, efficiency, and speed. But also, Dr. Ademola has taken us through the risks of using such tools when it comes to virtual hearings, such as, the risk of accuracy and accountability. We've seen that some AI tools have bias and they have the tendency to hallucinate. So that's also a risk. But also another major factor is confidentiality and data protection of, the participating people in that particular virtual session. But also another issue is an issue to do with legal recognition and enforcement of, AI-based virtual hearings or, submissions that are, made by AI tools, etc. And one of the challenges that Dr. Ademola has pointed out is the lack of robust legal and regulatory frameworks all across most of the countries to actually regulate AI, because AI you cannot escape, you cannot refrain from using it. You will apparently have to use it in order, to have efficiency in the virtual hearings, etc. So one of the key factors that we have to look into is the legal and regulatory frameworks to cater for, regulation of these tools. Another session that we had today, we had a session with Mr. Lawrence, who took us through cybersecurity. He took us through the cybersecurity principles. He took us such as integrity, such as technology must be apt. And another aspect he talked about data protection and privacy, and he highlighted the principles such as transparency, accountability, purpose limitation, amongst others. These are very key principles that we see most of the times enshrined in our local data protection acts as well. So these are things that must be taken into consideration when it comes to virtual hearings as well for both parties concerned. Mr. Lawrence also took us through cybersecurity safeguards that people should have in order to mitigate or rather prevent cybersecurity incidents, such as multi-factor authentication, blockchain or digital signatures, and incidents reporting mechanisms that can help mitigate after fact. Another aspect that Mr. Lawrence talked about is the sensitivity of some of the data that is being collected and processed during the virtual hearings, or rather, by lawyers when they're using these AI tools, data that identifies individuals. So how do we best adopt practices that can protect these personal data? Another aspect he also highlighted about is cybersecurity risks when it comes to cross-border transfers. Because when it comes to virtual hearings, sometimes parties can be from different jurisdictions, and so they can be sharing different information all across, and so that brings into account matters to do with cross-border data transfers. We had another session with Mr. Nathan, who took us through artificial intelligence as a source and subject matter of disputes. That in certain circumstances, AI is a tool that we use in virtual hearings, in lawyering, and it is helpful, but it could be a source of disputes. He went about talking about the challenge, the issues to do with challenging decisions that have been generated by artificial intelligence tools. So he also elaborated that, because AI as is still is under development, is still developing. Every day it's changing. Sometimes, some AI tools can suggest non-existent cases or non-existent sources that would lead to, submissions being challenged, or, questions to whether these lawyers who submit these submissions, which are generated by AI and which have, false or misleading information, should they be disciplined, or what other mechanisms rather can be used. He also, Mr. Nathan also talked about AI malfunctioning, and he gave an example of a law firm whereby the tool malfunctioned and threatened to actually expose some certain details. Because they were saying that they would shut it down. So we can see that there are certain incidents that would pose as risks when it comes to use of AI tools, when it comes to virtual hearings and just lawyering in general. Mr. Nathan also took us on the recent developments, such as the AI-based law firms that are being generated now, although he said that they have limited capacity, such as to help people draft just documentation and the likes. But these also pose a risk in terms of all the risks that I have highlighted. But also he highlighted on the readiness of courts and judicial systems to deal with AI-related risks. As I've said, there are some tools that will cite non-existent cases or authorities, so are courts really ready to vet, to see through if this decision actually exists, etc., on the basis of those AI-generated submissions. And he also highlighted on the AI tool that is being used by Hogan Lovells, Craig, and how it helps their law firm to actually have efficiency when it comes to matters that they're dealing with in their law firm. And finally, we had another part, the role of lawyers when it comes to AI. So lawyers have to be AI ready. So when it comes to training themselves, equipping themselves to be able to understand how these AI tools work, the risks involved, etc. But also apart from training themselves, lawyers need to train their clients as well. They need to inform their clients. Also, they need to seek consent from their clients. They need to explain that they're going to be, onboarding their personal data in these particular tools to generate, some sort of summaries or to generate just submissions, etc. So having said that, for the interest of time, we are going to start with the question session. And the first question, I would like to direct this particular question to Mr. Nathan. Mr. Nathan, how should senior lawyers now train the junior lawyers so that they have the insight needed to supervise AI-enabled legal practice? Or rather, how can junior lawyers strengthen their value in the new environment?
Yeah, I mean, I think that those are great questions, and they look at it from the two ends. I mean, I think, as I say, those people who use AI tools well, have that critical thinking, because AI simply, follows the rules, and for how it analyzes data. So it's important that junior lawyers understand how the AI has got to the answer, so that they can explain the process, because judges and arbitrators want to know, and it's important for the junior lawyer to be able to verify what AI has done, and also to be able to set the rules and also be critical of the rules. Where are the rules going to break down? Yeah, I think junior lawyers who say, "Oh, I've got this AI tool. It's just done a summary." Yeah, I was asked to do a summary of the benefits of AI. Yeah, I've just plugged it into a free AI bot, and it's come back with this answer. Those lawyers who take that unthinkingly, uncritically, and don't understand what the process has been, how it's got there. I think those are the ones who are not going to be able to to deal with the very well with the AI applications, and those are the ones that are high risk. Whereas a junior lawyer who understands the product and says, well, look, this is a product that gives me X% accurate translation of this. Yeah, so I've used this as a first. We may need to, if it's an important court document, we may need to get it certified, but actually for the purposes of seeing whether it's relevant or not, it seems to me to have done a pretty good job, because this is not the translation of the key contract where the wording's going to be critical. So again, people be able to distinguish between those different use cases. And also junior lawyers who know what's out there in terms of AI and can say to the partner, well, I think we should be using AI to do this or that. Are you fine with me as a starting point using AI to pull together the some of the speaking points, and then I will go and verify those points and provide supporting authorities, etc., so that you've got someone who's say, yes, I can use the AI as a good starting point, but I can't just type it into AI, go to the partner and say, yeah, here's the answer without verifying it. So I think that's the real way where you can add value, I think, as a junior lawyer, because you'll likely be more familiar with some of these tools than partners like myself who were qualified several decades ago. So you positively suggesting, etc., can be I think it can really add value and be seen to be, well, look, you're looking for ways to be efficient. But I think know the limitations of the tools so that you can pick the right one, but also ensure that you're not over relying on on the AI, because the danger is that the AI does a good job on the first one, on the second one, etc., but on the third one it makes a massive error, and if you've come to over rely on it, you're going to be in trouble.
And let me just quickly add something, just picking up on Nathan's comment about how old he is. Just in relation to, so for a senior to be effectively able to train a junior, I think they themselves need to be very familiar with technology. So I think that's the starting point. So if you're going to train somebody on how to effectively use technology, you should be familiar. So I think the starting point, in addition to what Nathan has said, is that seniors, we need to know the AI tools. We need to know how they operate. We need to be familiar with limitations, because that's one way by which you can effectively train junior lawyers. That's one. Number two is what Nathan has already said, just re-emphasizing the fact that these tools make mistakes, and so re-emphasizing that. Now, to the junior lawyers, I think AI is not all-knowing. AI cannot perform everything. And so my advice would be, think about things and think about functions that AI cannot provide. So, so that's in addition to doing what the senior lawyer is doing. So you need to be familiar with AI, but for you to be relevant, and I'm just looking at the second part of Gordon's question, how do you stay, how can junior lawyers strengthen their value? It's in addition to being on top of the AI tools, because you cannot run away from it. That's just the reality of things. In addition to being on top of it, you start to think of value that you can bring that AI cannot do? What is the value that you can bring to the team? What is the value that you can bring to the work that a machine cannot do? And those are skills, those are experiences that you should start to hone in order to distinguish yourself from AI and your other colleagues relying heavily on AI.
Thank you very much for that response, Mr. Nathan and Ademola. Again, back to you, Ademola. What are the precautions to have in mind when using AI on issues of data privacy and access to confidential documents in law firms? What precautions should we have when using AI accessing these confidential documents?
You're on mute.
Sorry. That's why we need an AI device to tell me when I need to unmute. But I think first of all, it goes back to training. Organizations need to train their staff members on, on access to confidential documents. They need to train their staff members. So I think that's the starting point. And so, yes, individuals need to take responsibility for their training. Organizations need to take responsibility for their own training too. So I think that's the starting point. The second point that I would make is do organizations have guidelines to guide their staff members in relation to some of these limitations? So do you have like guidelines on what to do in certain instances? So that's something to have in mind. Number 3 is, and so for example at Hogan Lovells, we have an AI tool, we have guidelines, but even in using the AI tool, there are questions that the tool would ask you. Have you sought for permission? Is the client aware of this? Are there confidential? Is there confidential information that shouldn't go out, even though ours is even still internally generated? So those are things. Those are things that you could put. And I think going on to something that Lawrence made reference to is, can we have firewalls that would limit setting the use in some way, so that people are not just taking stuff and using AI tools that are not that expose the organization to risk. So I think those are 3 things that come to mind off the top of my head based on your impromptu question.
All right, thank you very much. We have another question. Has AI come to displace professional and critical thinking? So if Sophie, you can answer this particular question. Has AI come to displace professional and critical thinking?
Yeah, it's a great question. I would say the answer is no. It's not come to display. AI's capabilities haven't advanced to the point that they're able to displace things like professional and critical thinking. And also the thing about AI is that it's becoming integrated into our processes, and it's becoming integrated into the way we do things at the firm, but it's not making the final calls or those kind of judgment calls and that decision-making aspect of things that are ultimately why lawyers are so valuable. And I think AI, it will only get better, but there are elements to being in a client-facing business that that you simply can't replace with technology. And I think that's why I personally feel quite confident that we will not get to a point where we're sort of seeing our profession being taken over by AI, although it will help us with a lot of kind of these administrative tasks and getting integrated into our processes. It won't ultimately take away that aspect of things.
Thank you very much, Sophie. We have another question here, and I would direct this to Mr. Lawrence. Mr. Lawrence, what is meant by bias in relation to AI? Can you please explain what is bias? Mr. Lawrence? Dr. Demola, oh, you're here, Mr. Lawrence?
Yes.
Yes,
Yeah,
please,
I
could you?
think I think it is more of how the AI system processes the information. That is actually what is biased, but I think Dr. Ademola can be able to give more insight into that.
Yes. So I think when you talk about bias, so AI tools they've been built by human beings. And in creating the AI tool, they've created it based on certain codings. I'm not a tech person, but they've created it based on certain information. So with this information, you should be able to come to this conclusion. You should be able to source for information from this. And so when you talk about bias when it comes to AI, it's the fact that the output or the results that AI would generate or would give you is based on what the tech man or woman who built the AI tool has put into it. Now, obviously, they try to make it as rounded as possible, but again, I think look at it in the context of what I said the other time, which is that sometimes because many of these AI tools may not be made in the continent, it's possible that when an AI tool, for example, is giving a response, it's not taking into consideration the fact that, oh, the person who has asked me this question may be asking me because the person is in Tanzania or because the person is in this jurisdiction. That's an example. Or if the AI tool was made, I'm giving this as an example again, was made somewhere and you're trying to prepare submissions in Uganda, it's possible that the AI tool is not factoring the fact that, oh, the gentleman or woman who is asking me to prepare submissions is in Uganda and would need it to be tailored. So we just need to be aware of that. I expect that as time goes on, AI may be able to overcome some of these challenges. But when you're aware that, it's possible that there may be certain biases in the way this tool may have been created, it affects the results that may be generated. And so you approach it based on that perspective. I don't know if that makes sense.
Yes, you do. Nathan, you wanted to say something?
Yeah, it's again that garbage in, garbage out. Yeah, if you ask an AI tool, is AI a good thing? Yeah, you'll expect it to say it is. Yeah, and are there big risks? Yeah, and so try some of those type of questions. And bias arises from largely from two sources. One is the rules that it is applying and analyzing. Sometimes, as Ademola said, in those rules themselves, they are making judgment calls and excluding certain things. And then there is the data set. And you don't know what the AI companies say, well, where we're getting the data from, that's part of our secret source. And so you need to be quite careful, with that. And AI doesn't always, as lawyers, we always say, well, this sentence comes from this source. The AI doesn't always link it up in that way. And so you can have bias from a data set in a number of ways. One is that it excludes, as Ademola says, certain core parts of the data. And so you're taking a percentage of the X percent, but actually you're not looking at the whole. You're looking at only a tiny circle. It can also be the AI can also give disproportionate weight, where there is balance to an argument. How much of the data set is it giving weight to? And also where views have changed over time, the AI might just look at the data set as a whole. And so it might take, say, quotes from 50 years ago and quotes from 5 years ago, and unless you've told it that you have to give these things different weights because things have changed, then you get this mismatch or mishmash of views on an issue 50 years ago, which might no longer be or hundreds of years ago. There was a time when the prevailing view was the world was flat. That's no longer the case. But if you're giving equal weight to views over time, so those are some of the types of bias you might need to think about. And it comes down to, and this is a critical thing with confidentiality as well. What are the terms of the AI assisted tool that you're using on the internet? When I put this data in, am I saying that the AI can learn off it? Am I saying that the person who controls the AI tool, that's their data now? Because that can be quite scary. So it's important that people know to look at the terms and conditions and understand what it is, because that will then help them from a risk perspective know what they can and can't put in.
Thank you very much, Nathan. I'll be taking the last question. The rest of the questions that will not be responded to, please kindly channel them through the East Africa Law Society, and they shall be able to assist you. The last question to all the panelists, just to give their final remarks. In jurisdictions where courts are open in the general public, how do you comply with authorization and authentication of people attending or allowed to attend a virtual court session? So when it comes to virtual hearings, because some cases are subject to general public to attend physically. So when it comes to virtual hearings, how do you authenticate or authorize the general public? If all of you panelists could please just give your brief responses.
I'm not sure I fully understand the question, because I would, well, if I were to say something, I think the same way we've run this, webinar is one way of dealing with it, which is, fortunately or unfortunately for us, some of us have more control over the webinar than some other people. So I think if we approach it from that perspective, which is, yes, it's open to members of the public, but the courts, the judge, and the clerks and members of the court system, the judiciary, have more control over members of the public who will just be joining randomly. Obviously, participants are not random, but I'm just saying in the context of court hearings, I think that's one easy way of dealing with it. So I guess in summary, the way to deal with something like that off the top of my head, and I'm not a cybersecurity expert, is just the same way we've dealt with this webinar. Certain people have more control than the other. The people who are core and related and necessary for the hearing would have more control and can unmute, mute, can speak, can smile. And for people who are just observing and participating, can just watch us just the same way we're watching. Yeah.
And what we have with the English courts is, when the list of cases is published, it will say if it's a virtual hearing, and the process is that those who want to attend can request from the listing office details of the hearing. So in terms of how it practically works.
All right, thank you. Mr. Lawrence, do you have anything to contribute? Just any closing remark?
Not for now, Edith.
Great. Sophie, do you have anything to add on to that?
No, I fully second everything that Ademola and Nathan just said.
All right, thank you guys. Thank you for participating in this particular session. Thank you to all the panelists for such insightful and very broad presentations. Thank you very much. On behalf of the East Africa Society, I would like to call Mr. Gabriel to give his closing remarks from the East African Society and call to action. But also, Mr. Gabriel, as you're doing that, you can please, could you please respond to one of the questions on how the East Africa community can, deploy our strategies with the continental AI strategy altogether to encourage national policies or to harmonize rather our strategy within the East African community. Welcome, Mr. Gabriel.
Thank you, Edith, and our dear esteemed panelists for this very thought-provoking and extremely important session. It's really been captivating. It's one of those sessions that you never want to end, but every good thing has a beginning, middle, and an end. So we were told when we were still growing up. But it's really excellent to have you, our esteemed panelists. Thank you so much for making time to be part of this very incredible session, and to you, our listeners, for joining in. The session has been streamed on Zoom and on YouTube, and I'm sure most of the participants on YouTube have been keenly following in. And in case you have any questions regarding the session, please send your questions to info@elosociety.org, and we will transmit them to the panelists so that they are responded to. On behalf of the entire society, our CEO, Mr. Sigano, and our president, Mr. Ramadan Abubakari, we'd like to thank you for making time and for making those wonderful presentations. And so the question posed by Edith regarding transmission of the strategies before the relevant committees or authorities at the ESC, I would like to intimate that at the society we do have standing committees, and interestingly, we have about 4 standing committees that work in the area of AI and cybersecurity. And so with the observer status that we have before the East African community, we are able to make recommendations and foster discussions on different thematic areas, and this is not an exception. So if that comes up, and I think as a call to action from this webinar session is to probably have a small working group that will work on actualizing this and having it submitted to the community for further deliberation. So certainly, it's something we can do, and we'll be liaising closely with our partners from ISLP to further have this discussion and actualize this goal. But that said, friends, ladies and gentlemen, we are 10 minutes past the hour 4. Please allow me to end this webinar session. And this discussion, ladies and gentlemen, does not stop here. Next month in October, which is a few days from now, we are launching a Tech Fest October, where we have 4 very carefully crafted sessions on technology that will be hosted in partnership with ISLP. And right here, this was the inaugural, and you can see how insightful it's been. And we'll not stop at the October Tech Fest, but we intend to host a session at our forthcoming annual Law Conference and General Meeting in Addis Ababa that will be happening on the 24th to the 28th of November 2025. And I'm happy to announce that we are likely to have a panel with ISLP, and some of the experts that you see on call will be there physically present to share their critical insights. So we look forward to hosting you. Our early bird rate is coming to a close on Tuesday, 30th of November. So you ostensibly have about 5 days to make that payment and grab that early bird offer. Remember that our early bird for young lawyers is $300 US, And for our senior advocates, about 5 years in practice, it's 350. With that, we look forward to hosting you again in October and to seeing you in Addis Ababa. Goodbye for now. Have yourselves a very lovely afternoon. Cheers.